Why don't you give us a takeaway why this decision was important?
I have one big industry takeaway, and it would be that
The Weekly Friedman, your source for the most essential information in the default industry. With your host, Adam Friedman.
Today we're returning to everyone's favorite New York topic, the Foreclosure Abuse Prevention Act, or FAPA. Enacted in 2022, the legislation sought to address concerns relating to purportedly abusive foreclosure practices, including reviving or continuing stale foreclosure actions that might otherwise be time-barred under the SOL. Guiding our conversation will be a recent decision, FLA Mortgage Capital v. Paul, a case that highlights the application of equitable principles and statutory defenses like FAPA. I'm Adam Friedman, managing partner at Friedman Vartolo, and today I'm joined again by our senior appellate counsel, Stephen Vargas, litigating counsel on this case, regular guest of the show, and generally the smartest guy in the room. How's it going, Steve?
Happy New Year. Nice to be back. First time I'm on the program this year.
Happy New Year. Nice to have you back. Before we jump in, do you want to walk us through the case? What are the relevant details?
There was a prior foreclosure. So this is the second foreclosure action. The first foreclosure action was commenced by Bank of America in 2009, which accelerated the loan. 2013, Bank of America files a motion to discontinue the action, which was granted in early 2014. Bank of America assigns the mortgage. Subsequently, it gets assigned to Trifera LLC. Trifera LLC commences a foreclosure action in 2017. The statute of limitations in New York, as everyone is well aware, for better or worse, is 6 years. The action was brought 8 years after the first action, based on the theory that the voluntary discontinuance of action number 1 within 6 years revoked the acceleration.
Okay, so Steve, the defendant's motion was filed after sale.
Right? That's correct.
Okay, so we're in a different situation, most likely, if this was filed before sale.
Correct.
Okay.
During the action, the defendant filed an answer alleging a statute of limitations defense, as well as a motion during the case litigating the statute of limitations. During the case, the plaintiff successfully litigated the statute of limitations defense. They successfully disproved it. Judgment was entered, and then the sale was held. And after the sale, the defendant tried to litigate relying on FAPA, arguing the statute of limitations expired.
Correct me if I'm wrong here. Their argument is, look, we answered. We filed a motion saying that this was barred by SOL. Their new motion, though, is their argument, had I filed those motions in a FAPA world, I would have won, but I lost because FAPA had not been enacted, and now FAPA is enacted. Let's go backwards.
That's essentially what they argued. They tried to argue during the case the statute of limitations had elapsed. The court essentially applying the Freedom Mortgage versus Engel holding, according to which the discontinuance of the prior foreclosure revoked the acceleration and reset the limitations period. Based on Engel, the court rejected their statute of limitations defense during the case. So shortly after the sale was held, the defendant made a motion relying on the FAPA amendments that retroactively purported to bar a unilateral revocation of acceleration by discontinuance, and said, based on the facts of the case, irrespective of the timing of our motion, the SOL actually expired and the sale should be set aside, judgment vacated, and complaint dismissed with prejudice as time barred.
I understand their point, because FAPA is retroactive.
This appellate department has not held FAPAs indefinitely retroactive. They have not addressed FAPA retroactivity at all. However, to your point, the first, second, and third departments, as of when this case was decided on December 20th of 2024, all had issued decisions applying the anti-Engel amendments, CPLR 3217E in particular, which was at issue here, retroactively. So yes, 3 of the 4 appellate departments have applied that particular amendment retroactively, and at this time had rejected constitutional challenges about retroactivity. The final answer to that will be decided by the Court of Appeals one day. But yes, it's been applied retroactively in every other appellate department. This department has not applied it retroactively or prospectively. They have not gotten into that particular issue yet.
But this decision is kind of saying we're not going to apply retroactively.
So in a sense, yes. So the court really denied their motion on 2 procedural bases. One, the defendants moved under 2 different statutes to try to get their FAPA arguments before the court. One was CPLR 2221E, which is governing a motion for leave to renew based on a change of the law. The statute itself and interpreting case law say that such a motion needs to be made for the time to appeal from a final judgment of foreclosure and sale expired. Here, defendants didn't appeal from the final judgment. The time to do so expired, and as a result, they forfeited any opportunity to rely on CPLR 2221E in a belated manner like they're doing. And then secondly, they moved under CPLR 5015A, which is a statute governing motions to vacate an order or judgment. That statute has 5 subsections that identify 5 bases in which you can move. And there's a case law created interest of justice standard. So basically 6 bases you can move under. Change of law is not among the 6 bases. So the court said your motion based on change of law was untimely. Your motion to vacate, purportedly based on a change of law, is not one of the bases that 5015 allows a motion to be made under. So therefore, change of law application is untimely. So even though the law may have changed, even accepting their arguments about FAPA as true, retroactivity, application to this case, it was not made timely. And purely on procedural grounds, the court said, doesn't matter about equitable bases, doesn't matter about whether the SOL actually expired based on retroactive application, you didn't make the motion timely. And based on that, your motion's denied, the sale's valid, the foreclosure can't be challenged further.
But let me just clarify. Was this a decision that can be used to say, I'm not saying perfectly, I'm just saying, is this a decision that can be used to say, maybe FAPA should not be applied retroactively? Or did the court kind of say, look, there's a lot of procedural reasons why we're not going to answer that?
Yeah, I think you could look at the decision in that manner. Certainly it's a case that on procedural grounds says you can't raise FAPA, but the other 3 appellate courts don't have any decision that's similar to this. Right. So it's unique in that sense.
No, I would say too, in a lot of situations, if the court doesn't explicitly say what you're hoping it'll say, right, and kind of punts a little bit on procedural grounds, maybe it's a win in the case, but it's not really a win big picture. But I do feel, and I'm sure you'd agree, in FAPA, it kind of is, because it feels like the court is trying to push in every instance. And if this is an instance, which it sounds like it is, where the court didn't push and said, we're going to find a reason to punt, right? Because it doesn't feel like the court's looking for reasons to punt. They're looking for reasons to kind of expand FAPA, is how I feel. Yeah,
the trial courts, and even more so arguably the appellate courts, have found ways to apply FAPA, because it is important, for better or worse, for the appellate courts, ultimately the highest appellate court, to opine on the extent of the retroactivity, the constitutionality of the retroactivity, as it applies to each of the separate FAPA amendments. So I think the courts recognize that 2+ years after FAPA became law, and they're trying to address the FAPA amendments when the opportunity arises. Here, this decision is important because no appellate court has yet to rule on a fact pattern like this, where a defendant did not bring up the FAPA challenge until after the time to appeal from a judgment expired, and even in the situation where a sale's been held. Now, FAPA does have a provision, Section 10, that says you can't raise a FAPA challenge after the judgment has been enforced. So this decision is useful to show that the sale occurring is one way you can enforce the judgment. Arguably not the only way you can enforce a judgment, but the fact it's the only appellate decision in which any appellate court has said you can't use FAPA after the time to appeal from a judgment expired because the defense would be time barred under CPLR 2221E is very valuable, because based on that, all the trial courts in similar fact pattern are actually bound by this decision until one of the other 3 appellate courts issues a different procedural analysis.
Steve, this is great. It's definitely a big win. FAPA is something that there's just so many moving pieces. You're trying to figure out where it all falls.
It's exactly what it is.
So really big win. Congratulations. How would you wrap this up? Why don't you give us a takeaway to the audience with the big picture of, why this decision was important?
I have one big industry takeaway, and it would be that, like I mentioned earlier, it's the only decision of its kind holding that defendants can't rely on any of the FAPA amendments after the time to appeal from a final judgment has expired, because no other statute allows them to procedurally make that argument. So therefore, it's binding on all the trial courts, and all of the mortgage servicing industry and their counsel should be citing this decision in similar circumstances like this. It could be a very useful tool to deal with situations where the borrowers are filing bankruptcy petitions in order to show cause to stop sales, or did so in the past, and then try to raise the FAPA amendments after they became effective. This decision says you can't do that, which is extremely important because there have been delays, especially in the post-COVID world, where a pre-FAPA judgment hasn't resulted in a foreclosure sale yet. This case is essential to cite as a procedural defense to belated FAPA-related motion.
Thanks for joining Steve Vargas and I on The Weekly Friedman, your source to the most essential information in the default industry. Looking forward to seeing you next time.